We're back today with part two. 5 things attorneys don't know about paralegals, even though they work with them every day. Number 6, paralegals are a cost saving strategy. Leveraging paralegals effectively can improve margins, reduce burnout, and increase firm efficiency, especially in litigation heavy practices. So, having attorneys do every single part of the process to get documents prepared and document review and trial prep, that is a lot of work. You and I know it could be crazy. So, with that said, siphoning off some of the work, some of the workload to a paralegal will free up the attorneys to do some of the more thought intensive work that they do. 7, paralegals can help manage cases, deadlines, calendars, and more. Most firms pick a way that they work with their paralegal, and that's all they do. So a lot of firms that I work with will have paralegals specifically doing document templates, finalizing documents for briefs, and shells, things like that. But there are so many other things that paralegals can do. So it varies from firm to firm. And the reason I bring up that they can do other things is so you may have a docketing department, right? That person typically is some sort of paralegal. You don't want to hire someone that doesn't understand how to read the rules that affect docketing in the firm. Um, Managing cases. A lot of firms, especially if they're high volume, will have stages of the case that are very consistent. So with a good paralegal or even a decent paralegal, you can easily offshoot some of that to the paralegal and they will bring up to the attorneys, these are things that we're working on for the case, and kind of push the case along towards trial and or resolution. Number 8, paralegals must work under attorney supervision. It's a strange thing. I mean, attorneys know to an extent, but I think because paralegals are sometimes self-employed, attorneys may get the wrong sense that paralegals can do things like advise their clients on what the next stages are, and write a brief front to back without a lot of review. I've seen a lot of paralegals say, "Oh, my attorney gave me a document that they wanted, a brief that they wanted done, and I drafted it, revised it, and submitted to them to review, and they said, "Oh, don't worry about it. I trust you. Go ahead." Well, that's not how this works because you are the fiduciary as the attorney. Number 9, using the term paralegal incorrectly can trigger fines. Mislabeling unqualified staff as paralegals can lead to penalties under state law. Now, when this typically comes to play is when you have a attorney fee motion and you've submitted not only your credentials but your paralegal's credentials, and the judge says, "Wait, wait, wait, that's not a paralegal." That's typically when it comes up, and you do not. And that it could also come up if their CLEs are not current. We've talked about CLEs before, and so you do not want an attorney, a judge, sorry, pointing out that your paralegal is not qualified to be a paralegal. So it's very important that you check those credentials. Attorneys are responsible for compliance. Freelance paralegals are responsible for their own compliance, but attorneys are responsible for compliance. And it's just best to review the MCLE records and to keep, and of course their credentials, and to keep a record of that in the employee file as it comes up. A lot of firms will pay for the MCLE directly for the paralegal staff so that they can also have those documents in their system. And number 10, billing for paralegal time must be substantive. Same thing with attorney time, of course, but because there is such a variance between how firms use paralegals, sometimes attorneys will bill for things that are non-paralegal tasks, and that can come into play again when you're in front of a judge. Of course, you can ethically bill for whatever you want. You cannot ethically bill for whatever you want. Um, if there's something that should be performed by an attorney, you probably should have an attorney do it. And billing must reflect substantive legal work, not administrative duties. So, putting in calendar entries typically does not qualify, although a paralegal would do the docketing, does not qualify as an entry. In some instances, I've seen where, like for insurance billing purposes, that certain tasks that they explicitly will not allow paralegal to bill for, and same thing with an attorney. And that's all I have for you today. So join me again for part 3, and we'll see you next time. Bye.